and get started here for the day. Welcome to Corrections Committee. We're going to go over and start with requests for bill introductions, and I know Chairman Tarwater is here and has a bill introduction for us today.
Thank you, Mr. Chairman, committee. I'll give you a little background here. On October 10th, 2020, four of my really good neighbors and friends were hit by a train, and three of them died. Brent Maroney, Kevin Corbin, and Troy Hamlin, leaving a total of 7 children without fathers. The driver of the vehicle survived and was drinking. And what this bill would do would have this person pay child support if they take the life of a father with a DWI. So I would respectfully ask that you admit RS 230341.
All right, very good. Committee, any objections to that introduction? All right, seeing none, we'll get it introduced. Requested. Thank you. All right, committee, I believe we have Representative Howerton with us, who has a bill introduction as well.
Thank you. It's nice to be back in committee. I miss it. So I have RS 0253. It's an act concerning crimes, punishment, and criminal procedures relating to offenders on probation, parole, or post-release supervision required people who live with offenders to report certain behaviors. And it says, whereas this provision of this act shall be known as Lila's Law. Looks like Layla, but it's actually Lila. And this bill came to fruition from a constituent of mine whose daughter was sexually assaulted when she was 7 years old by a man on parole. So I respectfully ask that you would accept this in the committee.
Any objections to that request, committee? Seeing none, we'll get it introduced. Thank you, Representative. Are there any other bill introductions today? All right, seeing none, we'll go ahead and move on to our hearing on House Bill 2113, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2113 prohibits the denial of a petition for expungement due to the petitioner's inability to pay the outstanding costs, fees, fines, or restitution. It also provides that the waiting period for expungement starts at the date of conviction or adjudication and authorizes expungement of a juvenile adjudication if the juvenile has not committed a felony offense in the previous 2 years. Section 1 amends KSA 124516. That's the expungement statute for municipal court convictions and diversions. Current law there allows those convicted to petition the court to have the conviction and related arrest records expunged after a period of time has passed based on the offense after the person either satisfied the sentence imposed or was discharged from probation, parole, or a suspended sentence. This bill would change that period of time to start at the date of conviction instead of fulfillment of the sentence. The section is also amended to provide that a court shall not deny the petition for expungement because of the petitioner's inability to pay outstanding costs, fees, fines, or restitution. The petitioner's unwillingness rather than inability to pay may be considered as a factor in denying the expungement. The petitioner would still continue to be responsible for fully satisfying any outstanding costs, fees, fines, and restitutions, and the bill authorizes certain individuals to have access to the expunged records for the purposes of collecting those outstanding costs and fees. Section 2 amends KSA 216614. That's the expungement statute for district court convictions. Very similar changes here. Current law allows those convicted to petition after a period of time has passed based on the offense or the discharge from probation, community correctional services program, parole, post-release. This bill would change that period of time to start at the date of conviction instead of the discharge or satisfaction of the sentence. The section also is amended to provide that the court can't deny the petition for expungement solely because of the petitioner's inability to pay outstanding costs, fees, fines, or restitution. Again, the unwillingness rather than the inability to pay could be considered as a factor in denying an expungement. And the petitioner would continue to be responsible for fully satisfying any of those outstanding fees, fines. Section 3 amends KSA 382312. This is the expungement statute for juvenile adjudications. Current law there allows those adjudicated to petition the court to have the adjudication expunged if a certain amount of time has passed since the final discharge and other factors have been met based on the seriousness of the offense. This bill would change that period of time to start at adjudication as opposed to discharge. The section's also amended to provide that a court shall not deny the petition for expungement because of a juvenile's inability to pay outstanding costs, fees, fines, or restitution. Again, the petitioner's unwillingness rather than an inability to pay can be considered as a factor, and unless the court orders otherwise, expungement shall not release the juvenile from paying those outstanding obligations. The bill also amends subsection E1 to authorize expungement of a juvenile adjudication if the juvenile has not committed a felony offense in the previous 2 years and no proceedings are pending seeking a conviction or an adjudication. Current law there requires the court to find that since the final discharge of a juvenile, the juvenile has not been convicted of a felony or of a misdemeanor other than a traffic offense or adjudicated as a juvenile offender and no proceedings are pending seeking a conviction or adjudication. And I can take any questions.
Natalie, correct me if I'm wrong, but this comes to us from the Joint Committee on Corrections and Juvenile Justice Oversight?
Yes, that is correct, Mr. Chair.
Okay. I remember, I sat on that committee, and I remember part of this, but I wasn't there the last day. Discussing this idea of expungement period starting after conviction. So, I mean, is it theoretically possible that somebody could still be serving their sentence and be eligible for expungement at the same time?
I believe that it would, under the bill as currently drafted, be possible for that to happen. Right now, the clock, so say you have a situation where you're eligible to apply petition for an expungement after 3 years. That clock starts after you've been released from prison and you've served any post-release that would be associated with that, or your discharge from probation. But this would move this to start that time period at the date of conviction. So it's possible that you could still be serving a sentence at that time.
Okay. I don't remember that part of the conversation, but that's all right. That was a month or two ago. Representative Thompson.
Thank you, Mr. Chair. Kind of along with that, when it says restitution, this is my ignorance on this, isn't that part of the punishment?
Go ahead.
No.
Natalie?
Mr. Chairman, Representative Thompson, so restitution is ordered at the time of sentencing, and so that is part of the sentence that's imposed. What this bill would purport to do, parts of this bill at least, would be to say that even if you have outstanding costs, fees, fines, restitution, you can still get that conviction expunged, but you're still going to be liable for paying off any of those outstanding fees that you have.
All right. Representative Titus?
Thank you, Mr. Chairman. 2 questions, just to make sure I understand. This would kick in for the juvenile code, for anything a district court with normal expungement, and also the municipal court?
Yes.
Okay. And then the follow-up, how would this jive with HB 2028 we heard in judiciary that would start an automatic expungement process? If both those bills pass, do we have to do some reconciliation, or just want to make sure that I understand the interaction between the two?
Sure. Thank you, Mr. Chairman. Representative Titus. So for those of you not on House Judiciary, House Bill 2028 sets up a process for automatic expungement of certain records. That automatic expungement process actually doesn't apply to convictions. It only applies to the arrest records, dismissals, and so, or if, pre kind of conviction records. So this bill applies to conviction and post-conviction expungements.
Thank you.
Other questions, committee? All right, seeing none, thank you, Natalie. We'll welcome Marilyn Hart, a citizen lobbyist, as our proponent for this bill. Marilyn.
Thank you for this opportunity, Chairman and committee. I want to start with, I guess I'm quoting Representative Carmichael on the floor today, who said that there's a lot of advantages to consistency through legislation. And I think that's in part what this bill is about, because at least with regards to fines, fees, and restitution, we don't have consistency. And so in some places, people are allowed to expunge their offenses, even with fines, fees, and restitution due, and in other places they are not. So this clarifies and nicely deals both with all three entities in which expungement comes up: municipal courts, district courts, and juvenile courts. The wisdom of why one might get an expungement without fully paying their fines and fees is clear from the research. Some research done by the University of Michigan, which is the biggest study on this to date in 2020, found that in the first year of expungement, a person's wages improve by about 23%. And that increase is larger for women and Black study participants. So right now, we're denying people the financial benefit, the job and engagement in society benefit that comes from expunging their criminal record. Statistically, they're going to make more money because they don't have the money to qualify for that expungement. It is simply right now, this bill would allow people to have more money and therefore after the expungement, and therefore be in a better position to pay their fines and fees and restitution. The policy just makes sense. I do want to make a special note about restitution because like all of you, a few years ago, as I was wading into doing this work as a lawyer for people seeking restitution, I thought, seeking expungement, I thought about people and owing restitution. Like, why shouldn't we have that happen? But the truth is, in very many cases, those crime victims have been made whole by their insurance. And the person, the entity the restitution is owed to is an insurance company, which, yes, it's part of an obligation they need to do, but that insurance company might be able to wait a little longer for their money and, in fact, get it after an expungement happens. So the current law and my work in that area, just the number of people who happen to live in counties where the policy is that fines, fees, and restitution have to be fully paid, and who are struggling financially and can't make those payments, I can tell you as a practitioner in that area, is large. Unpaid court debt, which is what we're talking about here, is a major problem for people eligible for restitution, eligible for a public sealing of their criminal record in all other ways. And I just want to make sure that you all, that the term expungement doesn't get lost. What we're talking about here is public sealing of people's criminal records. It doesn't mean that law enforcement, judges at sentencing, even the Lottery Commission still has access to those records. It is merely, if you go on the district court record portal, which is now active in 100 of 105 states, counties in this state, and put in a name, you can see the public record. So we've moved beyond a point where in order to see someone's criminal record, the human resources people had to go to the courthouse and look them up, or pay a company to go look them up. We're far beyond that. And so now we have a portal which makes it a bigger deal for people to be able to seal their criminal records. And I will tell you, in the research that's being conducted in Kansas right now, where 350 people were signed up to look at the outcomes of expungement and to get our own number on what the income, what happens to the income. Those folks, most of them have one conviction. Most of those convictions are more than 10 years old, and they have simply either not known about expungement or not had access to a lawyer to help them with that process. So this idea of fines, fees, and restitution not being a barrier to expungement came out of a Judicial Council Advisory Committee in 2020. The part involving juveniles came out of a different Judicial Council Advisory Committee in 2021, and both those reports were adopted by the full Judicial Council. It also came out of the Joint Committee as a priority. And Representative Owens, the idea about starting the clock at the time of conviction came from Representative Carlin as her recommendation. I would agree with your concern about that as someone testifying and in that area. I know of no one other than her recommendation. I think where her recommendation came from is on this fines and fees issue. We do have some courts and some district attorneys who don't feel like people have satisfied their sentence until they've paid the fines and fees. So then the 3 years, the 5 years starts running at that point. And passing this bill would solve that problem without messing with the when things start. I do want to speak a moment about juvenile expungements because there's an extra part in there that changes juvenile expungements as it should be. It should not be harder to get an expungement of a juvenile offense than it is an adult offense, but right now it is. Because the requirement of the law is that someone not have any adult offenses before they can get their juvenile record expunged. Let me tell you about, and I refer to that in my testimony, a young man, Ricky, not his real name, who I encountered in doing this work. He was arrested as a juvenile for a situation involving his local convenience store. He stole some stuff. He got arrested. One of the things he stole was cigarettes. Well, the juvenile court does not enforce tobacco infractions, and so his city prosecuted him for the tobacco infraction. He went through the juvenile court process, was convicted of some other things, and after a period of time, once he became an adult, decided that he was seeing those things as a block to his future employment, and he wanted the juvenile record expunged. He wasn't too worried about the stealing cigarettes. He thought he could explain that to employers. But the juvenile offender tag that he came out of juvenile court with was a barrier to employment. So he tried to get the public sealing of that juvenile record. But he couldn't accomplish that because he had the city tobacco stealing cigarettes conviction, which was enough to bar him from his juvenile public sealing of the record. This law would make, and an adult could go in, and as long as they're 2 years from any conviction, they can go in and expunge this conviction and not that one, make their choices. But juveniles cannot. They have to essentially work backwards and qualify for the adult expungement, get that record sealed, and then work backwards to be able to get their juvenile offenses sealed from public view. It shouldn't be that way, and this law would make that change. So it would allow the expungement of a juvenile offense 2 years after completing the sentence, provided there are no other felony convictions in the prior 2 years. So it provides some relief. In fact, the convictions of any sort in the prior 2 years for an adult would bar the sealing. So it goes from, it makes some positive changes to allow youth who get involved in the system and are ready to face employment without having changed their lives without the burden that those juvenile offenses happen. I stand available for any questions, or if you want to do it at the end, I'm happy to wait.
Oh, you're fine. Committee questions for Marilyn?
I
I don't see any questions.
Okay.
Have a follow-up? Oh,
No, I'm sorry. I realize that many of you, I assume people know Maryland Harp Citizen Lobbyist. I've made reference to my work doing expungements. I retired at the end of December as the executive director of Kansas Legal Services for 43 years. So doing expungements and speaking to the needs of low-income people come naturally to me. I'm sort of excited to be unbound by the restrictions that came with that prior employment. And so I'm happy to be here speaking out on my own, which is where the citizen lobbyist title comes from. And I'm sorry.
oh, you're fine. Representative Carmichael, you had a question?
I do, Mr. Chairman, thank you. I'm not sure which one I should ask first because you've raised a whole bunch of topics that merit speaking to. I guess one place to start is, believe it or not, I do what's known as opposition research in politics. I look up people who run for public office to see if they're good people or bad people or otherwise. And I've been known to go back to the Wichita Eagle, where they at least used to publish the municipal court convictions and do searches for people who have had convictions expunged before they file for public office. And that's still there in black and white, and you can put it on a postcard. I also subscribe to online service that tells me about people's conviction records. And just because the KBI sends something to the Department of Justice, that doesn't mean these private companies remove that data from their database. Is there anything we can do about that? Or should we? Is it a First Amendment issue?
Yeah, I think it's a First Amendment issue, with this exception. You know, the people that make me frustrated about that is the company in particular called mugshots.com. That company, you might look at, they are successful enough at their business model that they have a standing open records request for all mugshots coming out of, in particular, Lawrence and Manhattan. Why those cities? You might wonder. They publish mugshots, and some of them are pretty funny to look at. Actually, they publish the funny ones. But they publish all of them, and they are happy to take you off, expunged or not, if you pay them $495. It is an extortion business model targeted at college students, sports, student athletes, and coaches, because that's why they do Manhattan and Lawrence in this state. And there are some states who've taken action about that, who have talked about those for-profit companies and ordered them to remove things at least when cases are expunged. Kansas has not taken that action, but there's something
Maybe we
that
can
could be done
explore
there.
that at a different time.
In a different way.
Bill. I'll reserve any other questions. Thank you, Mr. Chairman.
Certainly, rumor has it that they take cash credit, stuff like that too, and I wouldn't know from experience, of course, but rumor has it that that's the case. Additional questions, committee. Representative Smith.
Thank you, Mr. Chair, and thank you for your testimony on this. I'm a bit perplexed with the amendment to Section E1, where it talks about authorizing expungement of a juvenile adjudication if the juvenile has not committed a felony offense, and they leave it at that, right? Whereas before it also included misdemeanor offenses within the past 2 years prior to the ask, right? But I guess the way it's stated here, and I could look at the bill myself, I think of a case where I had an individual who we dealt with throughout high school, very violent individual, ends up going after a friend with an aluminum baseball bat. We get him with ag battery. He only commits the ag battery one time. He's adjudicated for that, but he continues with his behaviors, clear into adulthood. If this individual asks for an expungement of that felony conviction, that violent felony conviction, and yet he continues to use violence, and we have a misdemeanor record that's a mile long with him on different disorderly conduct to almost ag battery. Do we ignore everything but the ag battery then? And are we taking the discretion from the judge to look at that?
Nothing in this bill takes the discretion from the judge, because in all expungements, there is a requirement that the behavior and conditions of the individual present in a positive way. And if you want to, if you give me a minute here, I'll find that exact language. But a judge absolutely can bar someone from, the circumstances and behavior of the petitioner warrant the expungement. So a judge would certainly have that. Yeah, it's line 30 on page 12. I assume that's what you're being shown.
Well, the one we looked at is on page 19, line
Oh.
21.
Okay, sorry.
That's okay. Circumstances and behavior of the petitioner warrant expungement, yeah.
Yeah, so that's where a judge would absolutely, or a prosecutor would absolutely have a basis for denying that, even if they met the statutory requirement to present their petition. A judge could say, or a prosecutor could say, and then the person would have to come before the court and argue that their circumstances and behavior warrant the expungement. So there's always a place that folks who have not truly changed their lives can be denied an expungement. It's just not being denied because you don't meet those initial criteria.
Okay. Okay, thank you.
Additional questions, committee? No, Representative Carmichael.
The second area, time permitting, that I also wanted to inquire about was your remarks regarding insurance companies, insured losses, and that oftentimes the lion's share of that restitution ends up in the hands of the insurance company. Not that they're not entitled to it by law or by contract, but in terms of relative justice. One of the things, though, that also concerns me, at least, is the doctrine of subrogation and first dollar subrogation. And what that generally says is, by contract, if I have a $5,000 theft at my house, I don't ever get any of my deductible back until the insurance company's claim has been satisfied in full. In other words, the person has to pay more than $4,000 before the victim gets their deductible back. And I don't know that we can fix that here, but it's just an issue of concern in the context of where is this money really going? So that was my, wouldn't you agree? You don't need to answer, that was rhetorical.
Thank you. All right, any additional question? Yeah, we had Representative Titus.
Thank you, Mr. Chairman. Marilyn, when I look at this and responding to Representative Smith's question, we have the three criteria that a judge would consider, but when it comes to something like not paying restitution, it does seem like we are taking away the judge's discretion of whether or not restitution should be paid before. And is that the inconsistency among districts now, as some judges would say that it doesn't warrant and some does?
That's correct.
So that's my big concern, is that I'm, in full disclosure, the juvenile piece of this, I don't have much objection to, but with the municipal and the district court, including restitution in there, causes me some heartburn of warranting and expungement.
So I would just point you to the words inability to pay, because unwillingness to pay is not the criteria. So a judge could still deny someone based on their, if they had the financial means, their unwillingness to pay fines, fees, and restitution, not their inability.
Very subjective line in my experience.
I don't disagree with that, but it is the language is inability. So there is a financial need component of this.
Any other questions, committee? All right, thank you, Marilyn. Appreciate it. I show written proponent testimony from Lindsay Ford, Assistant Public Defender, Kansas State Board of Indigent Defense. Jay Hall, Kansas Association of Counties, and Eileen Berquist, Policy Director, ACLU. Are there any other proponents? All right. For neutral, we have John Goodyear, General Counsel, League of Kansas Municipalities, here to testify. John, go right ahead.
Thank you, Mr. Chairman, members of the committee, good afternoon. Grateful for the opportunity to come before you and to give testimony today on House Bill 2113. The League does support efforts made by the legislature to address cycles of indigency and recidivism. That said, we're always a little wary of provisions that would remove methods to ensure compliance with the statutes, ordinances, and court decisions. It's our belief, looking at this bill, that the intent of it is to preserve those necessary compliance measures, to preserve those requirements for individuals serving out sentences while helping certain petitioners to expunge those conviction, arrests, and diversion records and help address those cycles of indigency, those cycles of recidivism. So looking to this legislation, what do we like? It's important to our members that upon expungement, the petitioner is still required to pay these financial obligations, and that the expunged case file would still be available to the parties that need it to make sure that these financial obligations are met. Further, we are supportive of the distinctions made between inability to pay and unwillingness, and I agree with the representative's earlier comments that that might be a hard line to distinguish sometimes. So that brings us to the things that maybe we don't love about the bill. So does that provision need to be fleshed out? How does a petitioner demonstrate that they are willing but unable to pay? Do we require an affidavit of indigency or some other sworn statement by the individual that they truly are unable to pay, that the court can consider when they file that petition for expungement? And that can largely be addressed at the court level, but it might be something for this committee to consider as you consider the bill. Our bigger concern is the one that was brought up by the chairman earlier, is the change made to when that clock starts. Where the only elements of the sentence imposed are financial, it probably does make sense to make a modification to current state law to say the clock should start upon conviction, because we're no longer considering inability to pay and denial of expungements. So if the only element is a financial obligation, perhaps it does make sense to start that expungement clock upon conviction. But where there are other elements to the sentence, where there's jail time, where there's probation, parole, probably need to consider taking that back to satisfaction of the sentence and just excluding inability to pay from the element included in satisfaction of the sentence. And that's what prior versions of the bill did. It did exclude that the inability to pay or financial obligations from the definition of satisfying sentence. There was a specific provision in prior versions of this legislation that came from the Judicial Council. So a little tweak to that maybe establishes the timeline or more clarifies the timeline might be a good idea for the committee to consider if you're considering amendments. Happy to work with the committee if you're welcome to that. Happy to work with the reviser if you're welcome to that as well. So just as the committee takes up this bill, the League would respectfully ask that the method of demonstrating ability to pay be considered, and that we take a look at the clock, when that clock starts as you consider this bill, before making recommendation to the full House. And Mr. Chairman, I am happy to stand for questions at the appropriate time.
Thank you. Questions for Mr. Goodyear? Representative Carmichael.
Thank you, Mr. Chairman. Mr. Goodyear, as I recall, you are a member of the bar?
Yes, sir.
Okay. So you certainly understand that judges have to make subjective decisions and exercise their discretion virtually every day in a whole host of cases.
Absolutely.
Okay. So why is it with respect to the phrase inability to pay, you believe that we need something beyond that so as to restrict or limit a judge's discretion? Why would this be a special case where when it comes to sentencing and a host of other things, judges look at the evidence before them, they find it's either sufficient to show an inability to pay or they find it insufficient, and they exercise their discretion, and absent an abuse of that discretion, they're not going to be overturned. Why should we make this a special case?
Thank you, thank you, Representative and members of the committee. I probably misstated or did not state the position well. No, it's likely on me that I did not state this as clearly as possible. I don't think that's needed. I think we can trust our courts to make that decision. It's something that the committee can and maybe should consider what elements a court can take a look at, or a non-exhaustive list of things that the court can look at in determining whether or not it truly is inability versus unwillingness to pay.
I appreciate you giving credit to our judges because some of them are municipal employees, as you know.
Absolutely, yeah.
Thank you.
Any additional questions, committee? All right, thank you, John. Last minute addition, Ed Klump would like to speak in a neutral capacity on this bill.
Thank you, Mr. Chairman. Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriffs, Kansas Peace Officer. I didn't intend to speak, and I appreciate you allowing me, and I'll put something in writing and get it to Colette so you'll have it for the record. One of the reasons I wanted to come up here and speak is because of the discussion on when the clock starts. I am a member of the Judicial Council Criminal Law Committee and was a member of that committee when we reviewed this issue in 2020. And there was a significant, well, I shouldn't say significant, there was a discussion. It didn't last very long because it was very clear what needed to be done, and that was to not change when the clock started. And I have not compared this bill to the recommendation in that report, but it might be worthwhile for somebody to do that. In the report, at the end of the report, is actually recommended bill language that came from that committee. And there's also 4 recommendations that I assume is in this bill, but like I say, I didn't compare them, so I don't know. The recommendations that came from the committee was to allow the waiting period to begin before the person has completed payment of costs, fees, fines, and restitution, to prohibit courts from denying an expungement due to the petitioner's inability to pay costs, fees, fines, and restitution. A lot of discussion on inability versus unwillingness. And that's why that was put in there. And the wording that's in the recommended language for the bill in this report was very explicit to include both of those terms to impress the importance of distinguishing between those two. The third one was to require payment, costs, fines, fees, and restitution after expungement. And then there was also a provision to allow certain people access to the documents and information that are expunged for the purpose of collecting those costs, fines, fees, and restitution. I will send, along with my testimony, a copy of this report. I think it explains a lot of the things that some of you have been bringing up about the expungement process and everything. But I did want to express that the bill's recommendation to change the starting time of the clock was not a recommendation of the Judicial Council.
Thank you very much, Ed. Committee questions? Representative Carmichael.
I appreciate your historical perspective. It's valuable. Do you know if the language that we have in this bill as it relates to inability or unwillingness to pay generally comports with what the Judicial Council recommended, or do I need to do some studying?
I have not compared the bills, but I can tell you what our recommendation was.
That would be very helpful with the chair's
Let me
leave.
just find that section here in this.
Ed, while you're searching for that, Natalie has some input for it.
Okay.
Thank you, Mr. Chairman. Just so the committee is aware, last year, you guys heard House Bill 2556 and 2557. Those were the product of the Judicial Council report. So one of them dealt with the adult expungement inability to pay, and one was the juvenile expungement inability to pay. You guys combined those provisions into one bill, and then you passed it out, and then it died below the line on general orders. But this bill contains all those provisions from those 2 original bills, and then the only other change is the change to when the clock starts.
So. Okay. And to be clear, Mr. Chairman, I was not on the Judicial Council committee that looked at the juvenile side of this. This was the adult side. They intentionally split those between those 2 committees because of the expertise on each of those committees.
Makes sense.
So I think from what Natalie said, that probably matches what our recommendation was. But what that subsection reads is the court shall not deny the petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution, period. The petitioner's unwillingness rather than the inability to pay such costs, fees, fines, or restitution may be considered as a factor in denying the petition for expungement. So that was the recommended language that the Judicial Council put in their report. And Natalie brought up the juvenile. I will also include the Judicial Council's report on the juvenile side. It was a separate report.
Thank you for your assistance. Thank you, Mr. Chair.
Certainly. Any additional questions, committee? All right.
Mr. Chairman, thank you for allowing me to speak.
Certainly. We have written neutral from Laura Nordgren, Staff Attorney, Kansas Judicial Council. And then we'll have written opponent testimony from Todd Thompson, Leavenworth Attorneys Association. Are there any other neutral or opponent testimony today? All right. Seeing none, we'll go ahead and close the hearing on House Bill 2113. And now we're going to move into final action on some bills. But before we do that, committee, I feel like when we worked a bill a couple days ago that maybe we got in a hurry. And so I wanted to just take a brief step back and talk about how the process of working a bill goes, just so everybody understands it clearly. You will have each received in your email inbox by now something from Colette that she just sent out on my behalf titled For Review. And this is kind of the script for working a bill in a committee. It just kind of gives a basic layout of how working a bill goes. So I just wanted to touch on a few of these. So I'll begin by saying we're going to work the House bill, whatever. We'll have Natalie provide an overview for us, and then we'll consider any amendments or discussion. So this is our opportunity as a committee to kind of, what I like to say, cuss and discuss what we like, what we don't like. Do we want to pass it? Don't we want? Just it is an organized conversation of our thoughts, as well as any amendments that anybody has prepared to bring forward at that time. That would be the appropriate time. We would then work through any of those amendments through the standard process. And then ultimately, we would continue to repeat that till we finished all discussion and all amendments. At that point, I would then ask and entertain a motion as it relates to the bill. Do you want to pass it out favorably? Do we want to table it? Do we want to pass it out without recommendation? We'll entertain those motions, and then there'll be an opportunity for further discussion on that motion if there needs to be. It's certainly an option. But the idea really is to have the bulk of our discussion before we go there. So I'll ask if there's any other discussion, then I'll ask that individual to close. And after they close, that's when we vote. So I just wanted everybody to have a little bit better understanding. I realize that maybe our committee, as well as judiciary, might be ahead of the curve because a lot of committees aren't working bills yet, and so you may not have that experience. So are there any questions as it relates to the process of our committee and working bills? Yeah, Representative Carmichael.
Thank you. Sorry to keep doing this. Look like really good suggestions to me. I just want to make sure we somehow include this communication in our committee documents so that we don't inadvertently violate COMA.
Yep, it's been sent out to the entire organization. That'll be uploaded to our website as well.
Right, just so long as we get it up on the committee documents so everybody gets a chance to see it. Thank you.
Absolutely. Any additional questions, committee? Excellent. Well, thank you very much. With that in mind, we'll go ahead and work House Bill 2068, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2068 modifies how certain prior convictions are counted for the special sentencing rule related to possession of a controlled substance, and it also provides concurrent or consecutive sentencing for persons convicted of a new crime while they're on release for a felony.
Committee questions for Natalie? Seeing none, do we have any discussion or amendments as it relates to House Bill 2068? Seeing no discussion or amendments, do I have a motion as it relates to House Bill 2068? Representative Heiberger.
Thank you, Mr. Chair. I move that the committee recommend House Bill 2068 favorably for passage.
I have a second. Representative Slangenstiepen. Committee, any other discussion? All right. All in favor of, or you may close.
I close and move my motion. Thank you.
Thank you. All in favor say aye. Aye. Opposed? All right, the ayes have it. That is passed out favorably. course, Representative Carmichael, Representative Heiberger request their vote to be affirmative. All right, we'll now open House Bill 2069 and ask Natalie for an overview on that one.
Thank you, Mr. Chairman. House Bill 2069 provides that the service of post-release supervision shall not toll except as otherwise provided by law.
Very good. Committee, questions? Discussion or amendment as it relates to House Bill 2069? Yep, question. Representative Martinez.
Thank you. Could you explain?
Sure. Thank you, Mr. Chairman. Tolling essentially means stopping the clock for some period of time. So as an example, in the juvenile code, you guys have a provision that tolls their probation length limit while the juvenile is absconding. So anytime where the juvenile is not reporting for their duties or anything, that clock on the time limit stops and then it doesn't restart until the juvenile is located.
Thank you.
Certainly. Representative Heiberger.
Representative Martinez and I were having this conversation. I think it might be good just to clarify the situations where this occurs. I can give that a shot if you don't mind, Natalie. This applies when someone is on post-release supervision, commits another offense, is returned to custody, and then is arrested and returned to custody, and then is one still serving time on post-release supervision, then is also racking up jail time credit for a potential future conviction. And this bill would ensure that that jail time would apply to the time served on the post-release term. Accurate? Okay, thank you.
Very good. Additional questions, committee? Representative Carmichael.
So does that mean you don't get to count the same time twice? Is that what that's really saying?
Representative Heiberger.
Yeah, that and that it goes toward the post-release time rather than potentially jail time credit for the potential future conviction.
Theoretically, if you run out of post-release time, then does it go against jail time credit?
That's my understanding.
Mine as well, thank you.
Very good. All right, committee. No other discussion or amendments. Do I have a motion as it relates to House Bill 2069? Representative Smith.
I'll make the motion to pass this favorably out of committee.
Very good. Do I have a second? Representative Butler. Any additional discussion? Seeing none, you may close.
I close.
Very good. Committee, all in favor of passing House Bill 2069 favorably, say aye. Aye. Opposed? None opposed? Very good. We'll consider that one passed. All right, last one. Nope, yes. I forget. The vote recorded. My apologies. Don't look up. I just keep working. Thank you. Heiberger and Carmichael wish to have their votes recorded. All right, moving on to House Bill 2070. Natalie, would you give us an overview of that bill?
Thank you, Mr. Chairman. House Bill 2070 allows certain low-level non-drug offenders to participate in the Certified Drug Abuse Treatment Program.
Very good. Questions for Natalie? All right, seeing none. Discussion or amendments as it relates to House Bill 2070? All right, seeing none, do I have a motion as it relates to House Bill 2070? Representative Heiberger.
Mr. Chairman, I move that the committee recommend House Bill 2070 favorably for passage.
All right, second. Representative Smith seconds. Any further discussion? All right, seeing none, committee all in favor of passing HB 2070 favorably, say aye. Aye. Opposed, no?
No, I mean, yes, but I close and move my motion.
Oh, that too. No, but you mean yes? Got it. So we close it and we move it. Everybody was an aye. Was there anybody opposed to this passing out? See, even I need the script still, guys, see? All right. No opposition on that bill as well. Please record Representative Heiberger and Carmichael as aye votes. Okay, committee, we're done with our agenda for the day. Please note the new agenda came out and our meeting tomorrow is canceled. We had some changes with the hearing, so we just bumped the bill. We're going to work tomorrow to the following day on Thursday. So take an extended lunch, respond to the 1,000 emails that we all get, and the hundreds of meetings. So with that, we're adjourned.